We're live.
The Honorable Court of Appeals for the 7th District of Texas is now in session.
Good morning. We welcome you to the Wednesday, November 4th, 2020 settings of the 7th Court of Appeals, sitting via Zoom. We thank the attorneys for agreeing to appear this way. Of course, they didn't have a choice because can't appear any other way, seems like nowadays. But again, thank you for agreeing to do this. And we'll go on and call the docket. Your presence here indicates that you're ready, but just for the formalities, we'll go on and call the docket and let us know if you're ready. The case we have right now is 07-20-00020-CV, Andrew LeCody versus Barbara Kris Anderson, Charles Weber, David Kessinger, and Steve Blanchard. Mr. King, you ready?
Good morning, Your Honors. I am ready.
Thank you. And Mr. Vargas, you ready?
Yes, Your Honor.
Very good. And you've been informed that each side does have 20 minutes for their respective presentations, with the appellant, Mr. King, getting an additional 5-minute rebuttal. And I'm not sure if you've argued in front of the 7th Court of Appeals, but if you have, then you've heard these before. But if you haven't, we just want to let you know that sometimes we do ask questions. Sometimes we ask a lot of questions. So do your best to answer them as straightforward, and we will do our best not to impede your argument, but sometimes what you say piques our curiosity and we want to expound on it. So with that said, Mr. King, you have the camera.
Well, thank you, Your Honors. If it may it please the court.
Hold on a second, Mr. King. Judge Pirtle. Yeah. Oh, there you go. Okay.
Chief, could I say something?
Yes, sir.
Bobby, can you stop the timer? I'm sorry. I just wanted to make an announcement to counsel. We're hearing this individually in our respective offices, and each judge has a different setup. My setup is such that I have 2 screens, and I've got you on one screen and I've got your briefs on another screen, and my camera has a limited reach with the wiring. And so if I'm not paying attention to you, it's because I'm looking at your briefs, or vice versa. I'm looking at you and not looking at your briefs. So if the attention seems to be diverted, I want to explain to you why that may be. And the same may be true for Justice Quinn and Justice Doss, but just wanted you to be aware that if we're looking away, it's not because we're not paying attention. Thank you.
Thank you, Your Honor.
There you go, Mr. King. You're up.
Well, thank you, Your Honors. May it please the court. So I appreciate, again, you having us. This is not my first oral argument on appeal, but it is in the 7th Court of Appeals. So thank you for having us. Generally, in my experience, I get asked a lot of questions, and I don't even know if I need my full 20 minutes. And I don't know how much of the background you would like me to get into, assuming that the briefs have been read and the facts are fairly well developed as far as the general allegations.
It'd be right to assume the briefs have been read. Sometimes we touch upon the record, sometimes we don't before oral argument, but you proceed as you like until we interrupt you. Okay,
great. Well, thank you. Well, just briefly, my client, Mr. LeCody with Dallas Makerspace, was one of the founding members. He had a very key role in its development and growth, and he treats it almost like it's a child. And so I think in this situation, I know defamation cases are a lot more prevalent than they used to be. And I know the laws have been enacted to somewhat limit how a person can proceed. And I think the appellees in this case have argued this motion not only in the trial court, but in the appellee's brief, like an anti-slap motion to dismiss. And this isn't an anti-slap motion. This is just a Rule 91A motion, which obviously we all know is akin to a 12B6 in federal court. And the really only main issue in this case on appeal is whether there have been sufficient notice given to the defendant's appellees of what the allegations are. And I know on appeal, it's not the highest burden to meet, but in this case, I think it's very clear that they were put on notice that they were being sued for defamation, slander, and libel. And then of course, the intentional infliction of emotional distress. But I think the most focus in this case has been, the defamation and libel and slander. And
Counsel, is it just notice, or is it a little bit more than that? Whether or not there's basis, arguable basis, if you will, those are my words, but arguable basis, either in law or fact, to the claims.
Well, I believe it's twofold. First is notice that, of course, every petition and defendant has to be given, at fair notice of what the claims are against them. And I think the rules and the case law is clear. It doesn't have to be, a treatise on your case in the law. It just has to be some notice, general, pleadings, facts sufficient to put them on notice. And it also has to be, some facts alleged. Now, no plaintiff is required to marshal all their evidence and facts into a petition, because at that point, it's that person's version of the events, and a lot of the facts and evidence have yet to be developed. And I believe in any case,
you would agree, though, wouldn't you, counsel, that if we really do follow the Twombly and Iqbal standards that were announced by the U.S. Supreme Court, that plausibility is really what we're looking at when we're assessing the sufficiency of the pleadings, right?
Yes, and the sufficiency of the pleadings, the way I can a 91A motion is whether there's a recognized cause of action, and I don't think there's any dispute that slander, defamation, emotional distress are recognized causes of action. I would akin it more to if someone were to follow suit for one of my favorites, alienation of affections, that we know is not law on the books anymore. If somebody filed a lawsuit now for alienation of affection, that would be a 91A motion, because even though if there are facts, that's not a good law, and it would be subject to a 91A motion to dismiss. But defamation, while it may be difficult sometimes to prove, that it is still a recognized causes of action, which I believe the 91A motion looks at. Is there facts, and then is there any basis in law? And in a pleading, when you make your factual allegations, the burden is, are there some facts there that with every inference drawn to the plaintiff, that whether, it can be proven. And I believe in this case, while the facts may be, there may be questions as to whether at the end of the day, the plaintiff's case is strong enough to surpass a trial or summary judgment. There's at least sufficient facts pled and shown, even under Twombly, that there is, enough there to proceed and not be dismissed.
Go ahead. I'm sorry, Chief.
I was going to say, if we assume that everything that's alleged in the petition or live pleading is true, and I guess one of the defamations indicated was an accusation of violating the attorney-client privilege is somehow unlawful. What other defamations are there, and are they actionable defamations?
Well, I believe the one you're referring to is the attorney-client privilege, and that kind of goes back into my first point was, and I know these cases are very subjective, and there's a lot of gray areas about whether it's being argued like an anti-slap motion. When you accuse somebody of a crime, and I believe under this situation, that was all under the slander per se, which I know was gone over at length in the trial court, was that, it's a common law creation, and, slander per se, when you accuse somebody of committing a crime, falls under slander per se, and there's no extrinsic proof required. And it goes to, what does a reasonable person believe is the act, is the crime, and, is someone violating attorney-client privilege a crime? Well, as lawyers, we can argue that that's not a crime that would lead to imprisonment, but does the person know making the statement that is? I think that's where the subjectivity and the factual basis come in, that somebody might not have when the pleading is made.
Go on. I'm sorry.
In your pleadings, you allege slander per se. Do you have a per quad slander allegation that you're making, or are you resting solely on per se allegations?
In this, it was only slander per se.
And so as a result, you've got to prove one of those four categories, or you've got to allege sufficient facts of those four categories before you state a cause of action for slander.
Yes.
And correct me if I'm wrong, but I understood opposing counsel to be arguing his brief that when you accuse somebody of a crime, it has to actually be a crime, as opposed to something that's not a crime. So if breaching attorney-client privilege is not a crime, can you just say what you did is unlawful? That's defamation still?
And I'm familiar with the case law that describes that it has to actually lead to imprisonment. And my position is, what does the person at the time when they make the statement, do they think it's a crime? Now, we don't know that because, of course, we weren't there, and when you make the statement, if you believe it could lead to imprisonment, then at least that gives at least a foundation to make the slander per se allegation, is that they're accusing me of a crime, whether it actually leads to imprisonment or not. At the time they made it, did they believe that? And of course, when you file a pleading, you're not going to have that information from the beginning, but it's at least enough out there to at least put them on notice of, hey, I'm making the allegation that you accuse me of a crime. That's at least sufficient to surpass and get past the burden on a 91A. Now, as far as the other allegations, again, I know in the case law, I think it's clear that the accusing somebody of a crime doesn't have to be made in a technical manner. If they make the allegation that someone may have committed a crime, then at least that's enough to fall under the slander per se. And I believe in this case, some of the allegations were that some of the money in the Dallas Makerspace may have been mismanaged, may have been put in other places or used on things that shouldn't have been. And LeCody, being, of course, one of the founders and being a former board member, still has a lot of, I guess, a big presence still in Makerspace, even though at this time, I don't believe he was a board member. And so someone that has, such a presence and a reputation in something like Makerspace, the accusation thrown out there that he may have done something illegal, again, may not made in the express technical manner or use the exact buzzwords, as we'll call them, for committing a crime. I think here they were making the loose allegation that he had committed some sort of fraud, or maybe some sort of any other type of financial crime, which we know can lead to imprisonment. It's at least enough to show that while the allegation made, there is a factual basis there, because I don't believe that there's any dispute that those things were actually said. The meaning of them at the time, I think, is what's in dispute, but I don't believe that's what's really at issue on a 91A motion to dismiss.
What about the allegation that your client was uniquely harmed in his business or profession? The appellees cited to Section 573 of the restatement to say that your allegations, even if true, don't show a unique injury, that those are allegations that could be made against any person generally in the public who may be in business.
And referring back to that, and I think it goes back to what I was talking about just now, is that based on Mr. LeCody's role in the development and the creation of Dallas Makerspace, and his involvement even today, and when these factual and the basis of this claim were going on, that someone that has such a presence, again, he's harmed in it, because if he is looked at as one of the, again, using these kind of slang terms, like as maybe one of the godfathers of this organization that has such a reputation and respect around there, and maybe not necessarily seeing eye to eye with the board members, if these people are going out there saying that he did all these illegal things and everybody knows him there, then they start to look at him with maybe some suspicion. That harms his reputation within the makerspace that he spent years trying to develop, not only internally but externally, to get people to join, to get it out there, to get it known in the community, and he is a part of that.
Yeah, but it's my question, I guess, is that enough? I know when the Supreme Court in Hancock against Barium looked at Section 573, it said, look, when you've got a physician and you say a physician consorts with prostitutes, that's a statement of illegal conduct that could be disreputable to anybody in a particular business. But what the court is looking for is a physician's unique role, billing practices, way he or she deals with patients, et cetera. And that those are the things that really Section 573 is looking for whether we have somebody harmed in their business or profession.
And with Mr. LeCody's role being a former board member and having still a keen and involvement with the financials of Makerspace. And again, I think that was being really one of the main issues that started this whole issue, was that if he was accused of doing illegal things such as siphoning money, mismanaging it, then those accusations affect him, especially if someone is willing to, or, because I also believe in this case, he had been, deciding about whether to run for the board again. And I think we know that when politics are involved, things are said. But if these accusations being made, even though, quote, in general terms, he had done illegal and unethical things, that, he's being accused of something such as a crime or something that harms his reputation, that impacts what he can do within the organization. And by doing that, even though the people making these statements, if they're not aware of the meaning of the terms, that doesn't mean they still did say it. And being said, what they meant at the time, again, I and just like I argued in the trial court, I think is a fact question that is not necessarily at issue here, because if you're not given the opportunity to find out and develop what they thought at the time, then I don't know if that question can necessarily be answered, right now. But at least the allegation out there being said, and the way it was said, and based on his role in Makerspace, shows that there's at least enough there that there is a cause of action. There are some facts out there that it was said. The context and filling in the gaps, again, I don't believe is what a planner for Mr. LeCody necessarily has to show, at least to get past the 91A motion. I think that comes in later in summary judgments, or maybe in an anti-SLAPP motion had it been filed, or even a trial.
Let's segue to emotional distress. Emotional distress. The allegation. What is the alleged intentional infliction of emotional distress that was levied upon your client? What was said?
Well, so Mr. LeCody's wife, and she has, I don't believe she's necessarily as involved in Makerspace to the extent that Andrew is. So she had, I believe she still has it, cancer, but she was doing better, and or at least is doing better now. Last I was made aware that Andrew had colored his hair to show support for her, to stand in solidarity with her. And he had colored it. He had made his hair multiple colors. And I from what I can tell, and I believe that was brought up in the trial court, that it was common knowledge, within Makerspace that his wife had cancer. It was going through chemo and I believe radiation at the time as well. So he colored his hair for support. And the comment was made, I believe, was Skittlehead, that had been made, basically mocking him for showing support for his wife. And of course, he and his wife are very close, and they were taking it very hard. And so the allegation was that the statement was made intentionally to cause him distress because of this, because of the other issues that were going on with the board and the allegations made that give rise to the defamation claims.
Is the viewpoint at which you look at that claim an objective or subjective viewpoint, whether or not the individual would be subject to distress, or whether it be a reasonable person subject to distress?
And I'm sorry, could you repeat the question? It cut out just briefly.
Is the viewpoint a subjective one with regard to the particular feelings of the plaintiff, or is it an objective one of what a reasonable person would have thought or how a reasonable person would have reacted.
From my understanding, I believe when the statement, whoever's making the statement, it's what a reasonable person would believe could cause someone to suffer from the distress. So I would think that it would still be the reasonable person objective standard for the listener to hear it as well. Would any person hearing a comment made about their actions to support their wife, cause them distress? So yes, I believe it's an objective.
Is that a mixed question of law and fact? I guess my question is there a gatekeeping role, so to speak, that a judge would play to say a reasonable person would consider that enough, or a reasonable person wouldn't consider that enough? Or is that something a fact finder, a jury would have to determine?
Well, and I would argue that a judge's role is a gatekeeper, for true justice, and of course as a fact finder as well. So, and I think that goes to everything, whether it's in these pleadings or not, but especially with the defamation as well. The judge's job in a 91A, is to at least see if there's sufficient, notice given to what the allegations are, whether it's slander, libel, emotional distress, like here. Okay. And then they take the pleadings on their face. And again, we know in these cases, they can consider evidence. And then, they make a decision, but especially going back to your question in this case, was the judge given enough information to at least make a determination that while the facts are still being developed, is there at least enough there to make that gatekeeping to say, well, the allegation has been made. There's at least enough here to get past this, let's say this first gate to getting past 91A. Then yes, I would say that's certainly their role. And while I don't agree with obviously with their ruling, hence why we're here, that I think that when those determinations are made, it has to be of mixed law and fact. But again, going back to, like I said earlier, you're not required to marshal all your evidence in the beginning. You just have to there just has to be enough. And, we presented what we had at the time, and the allegations made on their face made a prima facie case that yes, there is enough here for at least the judge to make a determination, or at least that a judge could decide that there's enough there to go forward and have this case proceed, to, again, in these options, not anti-SLAPP or summary judgment.
Thank you, counsel. Your time's expired, and you will have 5-minute rebuttal.
Okay, thank you.
Mr. Marcus.
Thank you, Your Honor. I want to focus first on just what Rule 91A is and what the standards are, because I think there's some confusion, or at minimum, I don't agree with counsel's characterization. Rule 91A is two parts. It allows a party to move to dismiss a cause of action on the ground that it has no basis in law, or that it has no basis in fact. We make only the first argument. Appellees contend, trial court agreed, that appellant's causes of action have no basis in law, which means if the allegations in the complaint are taken as true, together with inferences reasonably drawn therefrom, if those allegations don't entitle the claimant to relief under the cause of action pleaded, the motion should be granted. The court may and should consider appellant's petition, the facts alleged in it, and the court may also consider appellee's pleadings to the extent necessary to determine whether the facts alleged, if true, actually conclusively establish an affirmative defense. That's in the Bethel case the Supreme Court handed down earlier this year.
Well, taking your standard and segueing to emotional distress, intentional infliction, you're saying we were to assume that the plaintiff, Mr. LeCody, was called skittlehead. The judge would be in a position to say calling somebody skittlehead is enough to raise, to go to the jury, or isn't enough to go to jury. The judge can make that initial assessment.
Absolutely. I think and I think you characterized it as a gatekeeper role, and I think that's what 91A allows and requires the court to take on, is sort of a gatekeeper role. Because the standard for intentional infliction of emotional distress is objective. The question is whether the conduct alleged constitutes extreme and outrageous conduct intolerable in a civilized community. By definition, that is an objective standard. It doesn't matter for the law how extreme and outrageous it felt to the person about whom the statement was made.
Let me ask you this, and I mentioned this. I'm in my 60s, and I grew up with All in the Family, the Jeffersons, and other shows like that. Blazing Saddles. I do not believe they can make another Blazing Saddles today. Years ago, the norms were such that you could say most anything, even if it's insensitive, even if it's racial. And they were saying it on TV. The norms seem to change now, that you can't say certain things, whether you call it political correctness or not. Do we have to factor that in as part of that gatekeeper? Well, the norms have changed, and what may have been appropriate years ago is not appropriate now.
I think even if the court does factor that in, the outcome is the same. All that's been alleged is one of the appellees posted a comment referring to an unnamed skittlehead. The appellant is asking us to assume that it's a reference to him. Even if we assume that, despite the lack of evidence, certainly, that is, playground name calling. That is, I think, the sort of thing that people say about each other all the time. I don't see it as being derogatory. I don't think members of the community writ large would see calling somebody a skittlehead as derogatory to the point of becoming extreme and outrageous in a civilized community in 2020 or any other year.
So it may be derogatory.
It's a throwaway remark.
It may be derogatory. It just has to rise to that level of derogatoriness, if that's the word.
Correct. Derogatory, simply because a statement is derogatory does not make it actionable under IIED. And the Supreme Court, time and again, and we've briefed these cases, and I'm sure the court has read these cases, the Texas Supreme Court has been asked to expand IIED, and they've declined to do it. It's a very narrow gap filler tort for things that are so outrageously harmful. There's no other remedy at law, and it would be unjust to allow it to go uncompensated. And that's simply not what's been alleged. The facts that are alleged don't come close to that level.
So you've got to live with some insults. That's the way of life, in other words.
Exactly. That's absolutely true.
Counsel, let me ask you a question. I'm familiar with the Twyman standard. When we're talking about something being unacceptable in a civilized society, is that civilized society defined as statewide, contemporary community standards? Do we look at the community in which the plaintiff lives, or do we look at a broader community? What's the scope of what we look at when we make that legal assessment?
Your Honor, I'm not sure whether there are cases defining the geographic scope. I think it would be reasonable to look at the community in which the subject of the statement lives. So the Dallas-Fort Worth Metroplex. I'm not sure that it, in this case, makes a difference. I don't think skittlehead would be extreme and outrageous in DFW, but not in the state of Texas or not in the United States. I think the result is the same no matter which geographic standard you might choose to apply. Going back, if I may, to Rule 91A and this argument about fair notice and whether the appellees are on fair notice of the claims against them. That's not an argument that we have made. There's no argument that there is not fair notice. Fair notice comes into play when the movement says the cause of action has no basis in fact. In other words, there aren't enough facts here to let us know what we've been accused of. That is not the claim. The appellees understand full well that they have been accused of defamation an intentional infliction of emotional distress, and they understand the factual basis of those accusations. We simply disagree, and the trial court agreed that those facts, even if they're true, don't meet the legal requirements. The claims fail as a matter of law, so fair notice isn't an issue. The issue is whether the facts alleged, if they're true, constitute in the first instance defamation, whether that's libel or slander. And as we briefed, there are two types of defamation: defamation per se, defamation per quad. I'm glad to hear counsel confirm my understanding, which is this is only a defamation per se case.
Well, and let me ask my follow-up question, because I was intending to ask you that question as well, because to me that actually is a question of law, and I wanted to see what your position is. I haven't seen any party briefing either side of it. It's this: is defamation per se a separate cause of action that's recognized in Texas, or is defamation per se merely a shortcut means to get through certain parts of your pleading and proof in a larger subset of defamation as a general category? In other words, is it like negligence per se, where it simply discharges your obligations to prove certain things, but if you fail to satisfy negligence per se, you still have a potential claim for negligence? Or is it a separate cause of action where if you don't plead it, you lose it?
My understanding from the Tatum case, which is the Texas Supreme Court's kind of reformulation of defamation that came down a couple of years ago, is that they are two separate causes of action: defamation per se and defamation per quad. Textual defamation versus extrinsic defamation. Defamation are different things with different elements. There are perhaps fewer elements to a defamation per se claim because there's no need and no obligation to go look for and determine whether there's extrinsic evidence that makes a statement otherwise innocuous become defamatory.
Well, certainly in Hancock, the court said as a matter of law, the statements were not libelous per se, but then the court went on to assess whether there was evidence of special damages that the plaintiff had presented, which is really an analysis that would have been inappropriate for a per quad defamation. And so I was just curious what your position was on that.
Our position is that, one, that the only thing that's been alleged is defamation per se. So I have not gone into the weeds of defamation per quad, simply because appellants made clear in their brief they're only alleging defamation per se, textual defamation, and that doesn't necessarily require proof of special damages in the way extrinsic defamation might. The question before the court is, do the words as spoken, would they to an objective observer constitute defamation? And the answer for each of the four types of statements that are at issue, the answer is pretty clearly no. And I'll run through them briefly. The first alleged defamatory statement, it came after my clients, the appellees, who constituted the board of directors, voted to suspend Mr. LeCody, the appellant, from the Dallas Makerspace. There's no dispute that that vote occurred. There's no dispute that the board's rationale was its belief that he had violated the attorney-client privilege by publicly disclosing a letter from the Makerspace's tax attorney. And there's no dispute that my clients, the appellees, went to the appellant in the Makerspace and told him the fact of the vote, the basis for the vote, and the fact that he had been suspended. That cannot be defamatory because those are all true things that happen. Saying to Mr. LeCody, even in the presence of others, we have voted to suspend you and here's why, is wholly truthful. And a truthful statement as a matter of law cannot be defamatory. So I think the first category goes right out the window. And if Mr. King has argued about the attorney-client privilege and the sort of subsumed allegation that Mr. LeCody violated the attorney-client privilege, even if the court drills down to that level, there is no authority for the proposition that violating the attorney-client privilege is a crime. And it certainly does not matter whether the speaker believed it to be a crime. I have seen no authority, I'm aware of no authority, that stands for the proposition that if the speaker accused someone of something that the speaker believed to be a crime that was not in fact a crime, that's actionable in any way. If the speaker accuses Mr. LeCody, for example, of murder, that's an accusation of a crime. Accusing him of breaching the attorney-client privilege is accusing him of doing a bad thing, but not a criminal thing punishable by imprisonment, which is the very high standard for defamation that hasn't been met. The next set of defamatory statements occurred at a follow-up board meeting where my clients, the appellees, essentially explained the basis of the decision to suspend Mr. LeCody, why it had been done. Again, these were, for the most part, completely truthful, factual recitations of the procedural history, for lack of a better word. One of the things that the appellate took issue with at trial level and in his brief, is a statement that of opinion from one of my clients that Mr. LeCody had breached a fiduciary duty. There's no dispute that statement was made. It's on the record. That is not an accusation of criminal conduct. That is, I think, at most an accusation that would constitute a general disparagement. And there's ample case law in this, including the Hancock case that we cited in the brief. A general disparagement, calling someone a liar, even calling someone a crook, that doesn't rise to the level of actionable defamation. At most, that is what happened in this case. And that's why the court was right to grant the motion to dismiss with respect to the board meeting comments. There is also a complaint about some written defamation in the form of a message board post from one of my clients, again, explaining the reason for the board's action. That's all this is. The disciplinary action, and I'll quote it, the disciplinary action against Mr. LeCody was based on the breach of the attorney-client privilege. And he also had the issue of his actions being detrimental to the corporation. There was a board action specifying that he stay away. He chose not to. Think of this as a parole violation. And their focus is on the last sentence, parole violation. That's an analogy at most. It cannot be the case that a reasonable person hearing that analogy would jump to the conclusion that Mr. LeCody had in fact committed a crime, been incarcerated, and was now out on parole. That, if that's the standard, then almost anything could be defamatory.
Counsel, what about the Facebook post where one of the defendants said, "We will hold him accountable for every illegal and unethical thing he's done"?
Sure, that's the last example. And that is, in fact, what the Facebook post says. And that, I think, goes back to the idea of a general disparagement, maybe being unkind, but it's not actionable. A statement implying that a party has done something illegal or unethical is akin to a statement that the party is a crook or a liar. And it has been the law for 70 years in the Fort Worth Court of Appeals, which is where this case originated, that calling somebody a crook and a liar without a verifiably false accusation of specific criminal conduct is not defamation, period. And that's where the court's gatekeeper function comes in. Look at the allegations, assume they're true, apply the law to them. The law says those allegations simply don't cut it.
And now a statement that we will hold you accountable for illegal activity. Is that an accusation that he engaged in illegal activity?
It is.
That just it's a position, we'll hold you liable. You shoot me, I'm going to prosecute you. I'm going to make sure the state prosecutes you.
Right. It's a forward-looking statement of intention. It's not a statement, you have done this specific illegal act. If you do an illegal act, we will hold you accountable. That's not defamatory. That's standing up for your rights. I don't know how that.
But there's a difference in the language, though. It's not forward-looking in that it intends to refer to future conduct. The statement refers to past conduct by saying every illegal and unethical thing he has done. Doesn't that imply or suggest that there's been illegal conduct that has occurred in the past?
Perhaps it does. And if the court construes it that way, even then, unethical things, that's not a crime. That accusing somebody of being unethical is mean-spirited, perhaps, even if it's untrue, but that's not defamatory. And saying that somebody or implying that somebody has done a generalized illegal thing without pointing to a specific crime carrying imprisonment as a punishment is, again, not defamation as a matter of law, no matter how the audience perceives it. It's the job of the court to answer this question as a matter of law. This is not something that should or would go to a jury. This is evaluate this statement, assume that it's true, that it was made. The law says, Texas Supreme Court, Fort Worth Court of Appeals says, that's not actionable defamation. I want to address just a couple of things that Mr. King mentioned. I think actually I've covered most of them. One was this idea of subjectivity, that it matters what the person making the statement had in mind about whether criminality or anything else. That's not right. This is a wholly objective test. What would a person perceive this, a person hearing this accusation perceive it to mean? It doesn't matter what the person making it believed, whether it's, accusing him of a specific crime or accusing him of something that they believe to be a crime. You look at the statement, not look at the mentality of the speaker. So there's no fact question that needs to be determined there. With respect to whether any of these remarks damaged Mr. LeCody's reputation specifically, I think they did not. I think that's a determination the court can and should make. Statements about doing generalized illegal things, even statements about money mismanagement, those aren't unique to Mr. LeCody and his position as a now former member of Dallas Makerspace. Those would be would affect the reputation of any businessman equally. There's nothing unique about Mr. LeCody or his role with the Makerspace that would cause unique harm to him. Unless the court has questions, I think I've covered everything I want to say, and I will give the court back 36 seconds of its time.
Could you address your motion for attorney's fees?
Sure. The simple fact is fees are mandatory. The trial court did not award attorney's fees. I think this court has the power to do that, and we've submitted a brief, and we can submit certainly further evidence. I think the court would be well within its rights to simply affirm the judgment on the merits and remand to the trial court for consideration of attorney's fees. The rule requires their award.
Was evidence of attorney's fees presented at the trial court?
Evidence of, may I answer the question?
Yes.
Evidence of attorney's fees at the trial level, attorney's fees through the date of the court's granting of the motion was presented to the trial court. Evidence of future appellate fees was not presented to the trial court.
Were appellate fees requested, even though there was no evidence?
I do not have our answer in front of me. I know fees were requested. I cannot tell you without pulling up the document whether there was a specific request in our answer and in the motion for appellate fees. I can certainly find it.
If awarding attorney's fees is mandatory, as you say, but you don't ask for them, does the court still need to give them to you? Sua sponte?
I think the court would be empowered to do that. Is the court required? I'm not sure I can go that far.
I guess it's a question of a preservation issue. Do you have to preserve it? The lights in my office keep going out because I'm sitting here so still. But so I apologize. But is it a preservation issue? You have to raise it in order to preserve it, raise it in a trial court in order to preserve it for review.
I have not found any case speaking to this issue with respect to fees under 91A that addresses that question one way or the other.
May I ask a related question? Are you required to file your notice of cross appeal if you want to seek that additional relief in the Court of Appeals?
I think that's a good question, and because it's not a cross appeal of anything the trial court did, I think motion practice is permitted. I think this could have also been a cross appeal, but I don't know that it was required to be.
Anything else?
No, Your Honor. Thank you for your time, though.
Judges, anything else? Thanks. Thanks, sir. Mr. King.
Okay, can you hear me?
Yes, sir.
Okay. So for my rebuttal, Your Honor, so the issue here is LeCody didn't file suit because of the actual being suspended. I think that's part of the whole story, but the basis is what was said about him. Now, one of the questions to Mr. Barkis was, is defamation, its own separate cause of action versus others. I think a lot of people use defamation as kind of the generic slang term. Slander and liable fall under. And going back to the per se, if it is per se, which is the accusation of a crime or damage to the reputation, it's not required that you have extrinsic evidence. Like, that's enough. It shows this is the allegation, no extrinsic evidence required. I believe extrinsic evidence is required on a per quad allegation, which again, we're not making.
Let me ask you this, and I think this may have been kind of the tenor of Justice Doss's questions, and I'll analogize it to lesser included offenses in a criminal setting. If you don't prove defamation per se, but can you say, but there's still some evidence of defamation per quad, even though you didn't allege it because it's kind of like a lesser included offense?
Well, and I do a lot of criminal cases, and when there's a lesser included offense, there's still there has to be some evidence of that lesser included. Okay. And so a per quad, if the evidence is there to show that to a lesser extent that it is a per quad, it's not waived because a lot of times in the indictments the DAs don't allege the lesser included. They always go big and allege the most serious case. And then, it's the defense attorney's job to, if they want the lesser included to try to put on evidence that there might be, the lesser included, at least ask for it in the jury charge.
Yeah, but in the criminal setting, where the court is now required to look for the lesser included, even if the state didn't want it, if there's a sufficiency issue. And I guess that's kind of the analogy here. If you're saying defamation per se, and we say there's no defamation per se, but there may be defamation per quad. And even though you haven't asked for that, are we supposed to say, oh, okay, yeah, defamation per quad?
Well, like I said, and I can't, like I said, necessarily quote to a specific case that answers that one way or the other. Then I would argue that if the evidence is there, and there's still some fact or legal basis to reach that conclusion that it should be allowed. Okay. And that's where you go to, then you start asking the question whether there's extrinsic evidence or not. And by going out there and saying, and I believe it's the Milkovich case, that if you say, well, I believe in my opinion, John Jones is a liar, you don't get to hide behind opinions and still say, oh, well, that's just my opinion that they committed the crime and without, and just say that, well, it's my opinion. Well, again, I also believe that in other cases that, the specifics, you don't have to make it in that specific manner. Oh, well, say allegedly, well, they did embezzlement or they were laundering money. As long as it's those allegations, general allegations that are made, that's enough to at least, meet the standard under Milkovich.
But counsel, here's my concern. And I mean, the legal standard is the legal standard. I guess we're going to make that determination at some point. But you didn't brief defamation per quad in your appellate brief. And so I'm concerned that we can't reach that issue now because it was never even briefed in the Court of Appeals.
And And yes, because most of the analysis here has been on the per se because of the allegation of the crime and the damage to the reputation within Makerspace based on LeCody's position in Makerspace. I think it's still arguable that even though it might not have been addressed specifically, it still falls under the defamation umbrella, which is still enough to at least have it pled and not waived. I think one of the other main questions, like you brought up as well, they're already talking about past actions. They're likened it to a parole violation. I mean, anybody can sit out there and say, well, I'm going to accuse you of committing murder. Well, and I can sit there and say, well, I don't believe that's imprisonment. You don't just get to hide behind your opinions and claim ignorance. As we always hear, ignorance is no excuse of the law. Well, you don't get to sit there and claim ignorance of the meaning and to say, oh, well, that's just my opinion. I have no liability for it.
Counsel, may I ask, and it's something that Justice Pirtle raised too with regard to the attorney's fees, and we asked opposing counsel, with regard to the appellate attorney's fees, do you have to request those in order to be awarded, or is that something that the court must do sua sponte because attorney's fees are, quote, mandatory, unquote?
Well, and in my experience, I always ask for appellate attorney's fees. I was always under the understanding that if you don't ask for attorney's fees before you rest, whether it's at the trial court or the appellate attorney's fees, you waive it. And in this case, there was no evidence put on of appellate attorney's fees at all. And I believe I submitted a response. Actually, I filed a response or an objection to the appellate attorney's fees with that same argument that, again, there was no evidence ever put on for it.
Okay. Any other questions, judges?
No.
Mr. King, your time's expired. We do appreciate both of counsel appearing through Zoom. The case is submitted and will be in recess. But again, I don't know how long it's going to be before the circumstances change that allow us to all appear in person. I think we all look forward to those opportunities in the future. But in the meantime, again, thank you for appearing through Zoom, and we will be in recess.
Thank you.